Good afternoon to everyone at today's public hearing of the Vetting Commission established under law number 65, year 2023, on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, Chair of the Commission, and I declare today's session open. The hearing is being conducted under law number 25, year 2023, on the external evaluation of judges and prosecutors and amending some normative acts, and under the Commission's rules of organization and functioning. The subject of today's hearing is Olga Cojocaru, a judge of the Central Court of Appeal, previously until the end of last year was known as the Kishinev Court of Appeal. Judge Cojocaru, welcome.
Bună ziua, bine v-am găsit.
Good afternoon. Good to see you.
Judge, as noted from our hearing notice, on the 5th of September this year, the Superior Council of Magistracy, on decision number 238/21, rejected your evaluation report and ordered the Commission to resume the evaluation process. In accordance with Article 20, Law 253, the Commission invited you to attend today's hearing. You will see we're joined by 8 other Commission members. Looking, I believe, from your left, you'll see Commission William Hansu, Marcel van Vettering, Julian Russo, Willem Brouwer, our Vice Chairperson, Andre Bevel, Loveland Perling, and Yuri Gatt. Also joining me online is Commission Member Brett Spring. You may notice also in the hearing room members of our Secretariat, representatives of the meeting, and members of the public. A photographer will take pictures just at the beginning of the hearing. Our hearing is being conducted with interpretation in Romanian and English. To allow for accurate interpretation, I ask that everyone speak slowly and clearly, and only one person should speak at a time. Proceedings are being recorded. The recordings of the public hearings of the Commission generally available online at www.vettingmd.eu within 3 days of the hearing. During the hearing, members of the Commission will ask questions. We ask that you answer truthfully and completely. Your explanations are important to the Commission in verifying financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will respect your privacy, and where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary information such as personal identification numbers, specific addresses. For the protection of privacy, we ask you to do the same. I will start by briefly reviewing the evaluation process since the SCN directed that we reevaluate the subject. The Commission on the 17th of April 2025 adopted an evaluation report recommending that Judge Cojocaru promote an external evaluation made under law number 253. On May 20, 22nd of this year, the Superior Council of Magistracy, by decision number 238/21, rejected your evaluation and ordered the commission to resume the evaluation process. In the period between June 24th, 2025 and July 28th, 2020, the commission asked Judge Cojocaru 2 rounds of questions to provide answers. On September 5th, we notified Judge Cojocaru of the commission's remaining doubts and invited her to attend today's hearing. Judge, do you wish to make any correction to the answer provided to the commission's request for information?
Esteemed Chairperson, esteemed Commission members, I would like to thank you for the opportunity to provide explanations. I submitted to the Commission my written position about the hearing of a judge, and if there are additional questions, I am ready to answer.
Judge, thank you. Let me ask 2 questions at the outset. Do you have any corrections or additions to make to the answers that you've provided to our previous request for information?
No, Chairperson.
And are the answers to the ethics questionnaire and the declarations that you returned on the 30th of April 2024 during the first round of the evaluation, are they still accurate?
Yes, Chairperson.
Thank you. Members of the commission will now ask some additional questions. We'll try to keep our questions short and to the point. We ask that your answers be short and to the point as well. And I believe Commission Member Lillian Ansu will start the questions.
Bună ziua, stimate doamnă judecător.
Good afternoon, esteemed judge. I suggest that we start your rehearing with the Gaskevich case, as you have been informed.
Și vreau să începem cu faptul că ne-ați comunicat
I would like us to start
despre faptul că cazul
with
Gaskevich
the fact that you informed us that since the Gaskevich case was on docket since 2013,
o întârziere de 12
had a
ani și
12-year
această întârziere,
delay, and
din
that
punctul nostru de vedere,
delay
este
from
atribuită
your point of view
părților
is
participante la proces.
because of the
În
parties
acest sens, vreau să vă
to
întreb,
the case. And to this
în
end, I would
calitate
like
de
to ask
judecător
you, as
responsabil,
a
ce
responsible
măsuri
judge,
procesuale ați
what
întreprins
procedural measures did
pentru
you
a
undertake
evita sau a
to
împiedica
avoid
extinderea
or
nejustificată sau
prevent this
tergiversarea examinării
unjustified
acestui proces?
delay of this process? Thank you for your question.
Nu știu dacă aș considera o tergiversare
I
examinării cauzei, domnule
don't
președinte, stimați membri ai
think,
comisiei.
esteemed chairperson and dear commission members, I don't think it was a moment of the case because the duration of that case is not imputable to my behavior as a judge.
Exclusiv circunstanțelor
It
obiective
was exclusively due to objective circumstances and conduct of the parties to the
Ultima cauză care a venit la
proceeding.
mine
The last
spre
case that
conexare,
I received to be joined, this, the Pagaskevich and
ultima
others,
cauză a parvenit
the
la
last
mine în
one
procedură
came,
în anul 2018.
was submitted to me in 2018.
Dosarul cuprinde, după cum am comunicat
As
comisiei,
I informed the Commission, this case included more than 70 criminal, almost 54 volumes and 125 credit cases, which gives it an exceptional level of complexity, and the delays, as I explained to the Commission, were caused by parties to the trial not being present, repeated replacements of prosecutors, requests for adjournment, interruptions that were caused by the pandemic, as well as medical or health issues of the parties to the trial. I believe that as a court, I showed diligence, scheduling hearings as often as it was possible within the boundaries allowed by the legal framework and availability of the parties. I believe that there are no elements that would reveal a deficient judicial management or an arbitrary behavior on my side. All the decisions were issued in compliance with the imperative norms of the Criminal Procedure Code and of the rights of the parties to a fair trial. Once more, the delays were not caused by me, but by the complexity of the case and the conduct of the parties. I have been diligent. I provided the Commission with information note, all the court hearings, and every time it was possible, cases were scheduled to be examined. So I would like to thank the Commission members, but I would like to also say that these delays were caused by external factors, not caused by my failure to act.
Putem continua.
Okay.
Haideți
So let's continue.
să vă amintiți dumneavoastră.
Could you please
Ați
recall,
spus că o bună parte
you mentioned that
a motivelor
significant
au fost
share of the
provocate de
reasons
părți și vreau să vă
were
întreb
caused by the
dezvoltați
parties, and could you
subiectul.
please elaborate?
Ce fel de acțiuni au
What
întreprins părțile
actions did
care au dus
the
sau
parties
v-au obligat
undertake
în calitate
that
de
made you or
judecător
obliged
să
you as a
extinzi
judge
procesul
to
de fiecare dată și
keep
să
extending this
detaliați
trial
clar
process?
care au fost acțiunile
Could you
părților în proces
please give
care,
details about those actions of the
în
parties
concluzie, au
that
generat examinarea lui
generated
12
the
ani.
examination of the process for a 12-year period of a trial? Once more, the last criminal case with the biggest number of volumes and the credit files was submitted to me to be joined with others. With respect to the conduct that you were asking about, I would like to tell you that the defendants, counsels, representative of the injured party, their failure to come to the hearing, they were asking for a time to answer the questions asked by the counsels. There are 5 defendants in that case.
La solicitări nu au obiectat niciun participant la proces ce ține de amânarea examinării de cauzei.
Trial did not object against the reasons that were leading to postponement of the case, and they were making requests to postpone because of medical reasons. And I'd like to mention that in 2020 it was the pandemic time. I'd like to reiterate that every request to adjourn the court hearings were discussed. Every request was discussed with the parties to the trial. No one objected against the established or the scheduled hearings, depending on the agenda and circumstances that were established for providing an additional period of time.
Eu nu dacă ați pune întrebarea dacă aș fi
If
tolerat
you
eu
were to ask
aceste
me,
amânări. Nu,
would
nu
I
le-am
tolerate
tolerat.
such postponements or
Am
adjournments?
aplicat
I did
strict
not.
procedura,
I have strictly applied the
iar
procedure,
în lipsa
and
participanților la
in the
proces
absence
sau
of
a unor
parties to
cereri
the
de
trial
amânare
or
puse în
having
discuție,
requests for adjournments
era
that were being
imposibil.
discussed, it was impossible to carry out the trial of
Reiterez
that
încă o dată,
case.
eu am dat diligență,
I
dovadă
reiterate,
de
I
diligență,
was
am programat
diligent. I
ședințele
was
de ori de
scheduling
câte ori a fost
hearings as
posibil.
often as it was possible.
Și aceasta se vede din nota
This
informativă prezentată Comisiei.
Can be seen in the information note that was provided to the Commission.
Dacă vă amintiți,
Do you
pe
remember
parcursul examinării cauzei, au
when you
fost
were
cazuri în
examining
care
that
dumneavoastră, în
case?
calitate
Were
de
there situations
judecător,
when you, as a
ați
judge,
respins cereri de
rejected
amânare a procesului?
requests to adjourn?
Nu pot să-mi aduc aminte
I
cereri de amânare, de
can't
respingere la
recall
moment, dar
cases when I
sunt gata să
rejected
ridic
such
materialul
requests,
dosarului.
but I am ready to look back into the case materials. But
toate chestiunile ce
all
țin de
the
amânare
questions,
au
all
fost
the matters
discutate
related
atât
to
cu partea
postponements
acuzării,
were
cât și cu partea
discussed
apărării.
with the
Nu au
prosecution
apărut
and
careva
defense
obiecții
sides. There were
ce
no
țin de stabilirea
objections about the scheduled times.
Colegi, dacă aveți
Dear
întrebări
colleagues, do you have any
referitoare la cazul
questions
Gacichevici.
about Gachkevich case?
În continuare, un alt subiect judiciar este
Another
cazul Caravita.
judicial topic is the Caravita case.
După cum bănuiesc că deja cunoașteți,
I
Curtea
suspect
Supremă
you
de
know the
Justiție
Supreme
a
Court of
constatat
Justice found
că recalificarea
that
apelului
requalifying
în
the
procedură de recurs de către
appeal
completul
to
dumneavoastră a fost
appeal on
o măsură
use
abuzivă,
of law was
lipsită de
an
temei
abusive
legal
measure that was
și mai
missing
mult ca
legal
atât a fost
justification.
realizată
Moreover, it was
fără solicitarea
done
vreunei
without
părți a procesului.
the
Vreau
request
să
of any
vă
of the parties to the
amintiți
trial. I
de
would
acele
like you
evenimente și
to
să
recall those
ne
events
comunicați
and
ce a
inform
justificat
us
această decizie.
Mulțumesc pentru întrebare.
what was the justification for that decision.
privința
Thank you for your
recalificării
question. About
apelului în
requalifying
recurs, vreau să
the
subliniez
appeal to appeal on
următoarele.
points of law, I would like to highlight the following.
Decizia a fost
The decision
rezultatul
was the
analizei
result of
cadrului legal
analyzing
existent
the
la momentul respectiv
legal framework that was in force at that time
și a consultării cu
and,
membrii completului, precum și
consultation
conducerea
with
cursii
the
de apel.
panel members and
Procedura
management
de
of a court of
lichidare a
appeal.
persoanelor
The procedure for
juridice
liquidation of legal entities
prezintă similitudini cu proceduri de
has
executare.
similarities
și
with
de
enforcement and
insolvabilitate.
the insolvency procedures.
Ambele reglementând
Both
soluționarea
of that
contestațiilor
regulate
prin
that
încheiere.
appeals are solved by means of determination.
În consecință, aprecierea că
Consequently,
dosarul trebuie examinat
The
în
decision that
recurs
that case was supposed to
a
be
fost
examined
una
on the point of
rezonabilă la
law
acel
was
moment.
reasonable at that time.
Actele emise
The
au fost examinate
documents that
de
were
către
issued
Curtea
were
Supremă
examined
de
by the
Justiție,
Supreme Court of Justice,
ceea ce dovedește că drepturile
which
procesuale
proves that the
au
procedural
fost
rights
protejate.
were protected.
Prin urmare, chiar dacă
Therefore, even though
Curtea Supremă de Justiție a
the
calificat
Supreme Court of
ulterior
Justice
soluția drept
qualified that
eronată,
solution later on as an erroneous one,
aceasta nu poate fi considerată
that
în viziunea mea
cannot
un act
be
arbitrar
considered
sau lipsit de temei
arbitrary,
legal.
in my point of view, or cannot be
Și cel
considered as
mult o
missing
eroare
legal
profesională
justification, but at most it
interpretare
could be a
juridică
professional error of legal interpretation
în limitele posibile pentru orice
within
judecător.
boundaries that would be possible for every judge.
Pentru a răspunde la
To
întrebare de ce
answer
ați
your
recalificat
question,
apelul
why
în
did
recurs
you
fără o cerere scrisă din partea
requalify the
părților,
appeal to an appeal on points of law without a written request from the parties?
aș răspunde în felul
I would
următor.
answer
Pentru
the
că
following way.
legea nu era
The
clară
law
la acel
was
moment,
not clear at that time,
iar completul
and
a
the
considerat
panel
după consultare
believed,
inclusiv cu
after
conducerea
a
curții,
consultation, including
că
consulting
aceasta
the
este
management of the court,
o procedură corectă.
that it was the right procedure to be carried out.
Ce ține de
When it comes to
întrebarea,
the
Curtea Supremă de
question
Justiție a spus că recalificarea
that
a fost
the Supreme
un
Court of
abuz
Justice
de
said that the
procedură.
requalification was a procedural abuse,
Respect constatarea
I
Curții Supreme de
respect
Justiție.
this finding of the Supreme Court of
Totuși,
Justice,
intenția noastră nu a fost
but
de a abuza,
our intent was not to abuse,
ci de a interpreta
but to
legea
interpret the law
într-un cadru lipsit de claritate.
in a framework, in the context of a framework that was missing clarity. It was
Și
a
nu un act arbitrar.
professional error, not an arbitrary act.
Dacă m-ați întreba cum pot
Should
demonstra
you ask me, how can I
că nu a
prove
fost un act arbitrar,
that it wasn't an arbitrary act?
am analizat și această chestiune și
Analyzed this, and I would answer in the following way.
am discutat soluția în complet.
We discussed this solution within the panel and with the leadership of a
A
court.
fost o decizie colegială
That was a collegial
și
decision.
motivată juridic.
It was
Chiar dacă
legally
ulterior s-a
justified,
dovedit a fi
even though
eronat.
later on it
Vă mulțumesc.
was proved to be erroneous. Thank you.
Eu suplimentar aș vrea să vă întreb
Additionally, I would like to
de la
ask you
înălțimea experienței dumneavoastră
from
profesionale,
the
cum
height of your
considerați
professional
dacă
experience,
instanța din oficiu
what do you think
modifică
if the court
acțiunea
ex officio is
apelantului?
changing
În
the
cazul nostru,
action
din apel
of
în recurs,
the
este
appealing
posibil
party
ca
from an
această
appeal to appeal on
decizie
points of law?
unilaterală
Is
a
it possible
instanței
that this
să
unilateral decision of a
aducă
court
atingeri
could
drepturilor și
interfere with the
interesului-
rights and
intereselor
interests
apelantului
of the
Sau
appealing
nu?
party or
Impactul
not?
unei decizii
The impact of a decision
pentru acțiuni de apel și pentru
on an
acțiuni
appeal
de
action
recurs
or
ar fi identic pentru
or
părți.
an action that would be an appeal of points of law would be the same. Would the impact be the same in an appeal case or an appeal of points of law?
Eu
I would
consider
like to
că
reiterate. I
actele care au
believe
fost
that
emise de
the
către și examinate de către Curtea Supremă
documents
de
that were
Justiție
issued and examined by the Supreme Court of
dovedește
Justice
încă o dată
prove
pentru mine ca judecător
once
că
more for me
drepturile
as a judge
procesuale
that
au
the
fost
procedural rights were protected.
Vă mulțumesc, colegi, dacă
Thank
aveți
you.
întrebări.
Colleagues, any questions?
Domnul Cojocaru,
Madam Cojocaru,
spuneți,
could you please,
cum a apărut această idee de recalificare?
how did you get this idea to requalify the appeal? Who suggested it? You mentioned that you discussed it, that you consulted the leadership of the court.
Completul
The
în care
panel
activam
in which
atunci
I was working at that time
a pus în discuție chestiunea dată.
raised this
Pentru că
topic into
nulitatea
discussion because
procesului verbal de licitație,
the
dacă verificăm
tender
practica
procedure
judiciară,
being no,
ea
if we
este
check
examinată în
the
procedură
judicial
recursuală.
practice, is examined
Această întrebare
in
a
a procedure that is appeal on points
la
of law.
noi,
We
motiv
had
pentru care
this
a fost discutată în
question,
complet.
and
Și
that was the
unanim
reason
am
why
ajuns
we
la
discussed it
concluzia
in the
că
panel, and we reached
urma a fi
unanimously
adoptată o
the
închiriere și
decision
urma
that
fi
a
examinată
determination
în
was to be issued and that it was supposed to
Am
be
fost,
examined
și la
under an appeal on
conducerea,
points of law.
curții,
We went to
domnul
the
președinte, dumnealui era-
leadership of a court and the president of a court.
lucra, nu știu acum dacă lucrează,
I
Institutul
don't know if
Național
he
de
works
Justiție.
now, but he was working at the
Este
National Institute of
specializat chiar
Justice.
în-
He
și în
is
procedura de
specialized
executare.
in
Dumnealui-
enforcement proceedings too.
Dumnealui la fel.
He
susținut poziția
also
noastră.
supported our position.
Astfel de cazuri au mai fost
Did you have
întâmpinate în
any
experiența dumneavoastră?
similar cases, like
După
any other
cazul
cases like
ăsta,
that? Not after
Colegii
this
au mai
one.
aplicat aceeași procedură?
Nu cred că
Others
atunci a
apply the same
fost,
procedure. I
discutată
don't think it was discussed
soluția
that
adoptată
the
din
solution
cadrul
adopted by us
ședinții
was
colegiului.
discussed in
Și s-a ajuns
the
la concluzia că
session,
Nu
in
a
the
fost-
meeting of the
a fost o
civil
eroare.
board, and they reached the conclusion that it wasn't correct, that it was an error.
Madam Cojocaru, this discussion with the presidency of the court, is there any written report?
Nu, nu.
No?
No,
None of this was.
Nu este o
No,
asemenea
there is
discuție, dar oricum,
nothing like that,
în cadrul
but
colegiului
still
civil
within
sau
the
în cadrul
civil
curții,
board or within the court,
deseori se discută între judecători. Da,
there are
o
often
opinie sau
discussions
alta
among
pentru a ajunge
judges
la o
about an
concluzie.
opinion or another in order to reach a conclusion.
Pentru noi a fost
For us,
important, având în vedere
it was
că în
important,
fața mea
especially
era o
since
cauză de
before me
anulare
I had
procesului
a
verbal de
case of
licitație
annulling the minutes of a
anterior nici nu a
tender
fost
procedure
să
that
vină în procedura apelului,
previously
pentru că nu era fond,
it
nu era
it
examinarea
never
cauzei în fond.
happened before
De apreciere
an
a unui
appeal
proces
because it wasn't
verbal de licitație.
on the merits to give to try to appraise or to assess a tendering procedure.
Discutat.
That's why it was discussed.
Dar dacă verificăm în
But
practică,
if we check
o asemenea categorie de
the
adresare se examinează în procedura de
process
curs.
such, or this category of cases is examined in the procedure of appeal on points of law.
So I take there's no written statement of the president or no written report on it at all. Okay, thank you.
Asta a fost la nivel de consultare.
This was just a consultancy process. It was not included in any report. We are doing this quite often, just as a consultancy process.
Cum credeți, cum
It's just like a discussion. What do you think? How is the practice? Because it's not an uncommon subject. Just to hear the opinion of another judge to be able to make a better conclusion. But by the end of the day, this was the conclusion of the panel.
Thank you for this clarification.
Mulțumesc.
Thank you.
Dacă colegii nu mai au
Okay,
întrebări
if
pe
colleagues don't have
partea
any other questions
judiciară,
for
vă
the
propun să
legal
mergem
part,
la partea
I suggest
financiară
we go to the financial
și
part
să discutăm
and
pentru
let's
început
discuss
despre
for the
anul
beginning about the
2015,
year 2015,
în care, potrivit estimărilor
where,
Comisiei,
according
ați
to the
înregistrat un
estimations of the
deficit
Commission,
de
you had a deficit of
19.000 de lei,
19,000 lei,
iar dumneavoastră ne-ați
and
comunicat
you
că
communicated to us
în anul
that
2015
in
ați
2015 you have
cadouri
received gifts
cu prilejul zilei de
for
naștere de la
their
rude,
for
dar
your
aceste
birthday,
cadouri nu au fost
and
declarate.
this was from relatives, and you
Prin
didn't
urmare,
declare
întrebarea
those.
este una firească,
So,
de ce
an
ați
obvious
decis
question, I guess.
că nu
Why
trebuia
have
să
you
declarați aceste
decided
cadouri?
that you don't have to declare those gifts?
Din prima rundă de întrebări am recunoscut
Okay, so
omisiunea.
from the first round, I recognized this
În anul
omission,
2015,
but let me tell you, in
diferențele
2015,
financiare
the differences
provin din
were
30.000
coming
lei,
from
provin din sprijin
those 30,000
primit de la
lei
rude cu ocazia aniversării.
actually came from the gift that I received, support actually that I received from relatives for my birthday. So why I didn't declare them at that time? I mean, these were real things, and these were usual family support. And they didn't represent any hidden or illegal source income. The lack of banking documents from those times, that period of time, reflects just the fact that it was an informal family gesture, and it was absolutely not about an income that I was hiding or missing to declare. And I mentioned this from the first round, and I recognize that this is my omission. Okay, so if we understand correctly, you don't have any documents, any proofs that could confirm the fact that you actually received that amount. No, I don't. These are gifts. It's not about something that people would give you with a bill. People are coming, bringing you gifts, and that's it. It's a practice. Maybe in other families it's not like this, but in our family, the family support, also financially, was always important.
Colegi, dacă aveți întrebări.
Okay, dear colleagues, maybe you have questions?
I do have a question, Mrs. Cojocaru. You just said you made an omission. And what was your omission exactly? Was it not mentioning the gift to the Commission, or not telling it about it?
In the declaration, I didn't include this in the declaration to the agency. And I actually spoke about this in front of the Commission. Yes, those were gifts for my birthday.
But you knew you were aware that you should have listed these gifts as income in 2015. I mean, you were a judge, you knew you were obliged. At that time, it was not so clear what exactly we should put in that declaration, because it was at the beginning. And then later on, the agency that was collecting that information gave us more insights. And then we understood and we started to make deeper declarations, so other type of declarations. It was lack of clarity how much or what should I declare, taking into account that that was just birthday gifts. And if it was a lack of clarity, did you ask for clarity in 2015? Because when you are uncertain about it, if I would have had such a request in that year to present specifically that information, I would have presented it. Because later on I understood that I had to, and later on it was after. And yes, I understand that it was my omission. Okay, thank you.
I would like to clarify also some aspects. You said that in your family it was normal to do that kind of gifts. I would like to ask about the people. Were only your family members, your close family members, or also not directly family members and some kind of acquaintances?
In Moldova we have those people that we call kumetri. So these are kind of people with whom we baptize children together, cousins that usually participate in our social life.
Did we know about your charge?
Yes, but these are just people that don't have any connection with the legal field. These are just relatives. And those clarities appeared for me much later. Many of my relatives were working in Russia. They were making money in Russia, many unofficially. And they would give such kind of gifts.
But you have strong relationships with legal system. Did you ask ever that, please don't do me that kind of gifts, I don't need them, thank you?
As usual, when people want to congratulate each other on birthdays, in Moldova we give money to each other. Many people are bringing unnecessary gifts, yes, but in our family, we just give each other money in order for the person to buy what the person really needs.
I would like to understand your values. Do you still think it's normal? It's okay? It's part of your culture and that's normal way how to live and how to do the gifts?
Cred că nu.
Now I think no, I would not.
Atunci așa erau.
Because in those times it was like unwritten rules.
Acum, la moment,
But now, after,
mai ales după
mainly after this kind of evaluation, definitely not.
Thank you.
Vă propun să continuăm cu
I suggest to continue with the year 2021 for the same financial dimension. So you have declared that in 2021 you have received a donation from your mother, 36,000 lei. So that amount. And taking into account that the pension of your mother for the whole year was 44,500 lei. So if we make some simple math calculation, we understand that it's almost the whole income that she received that year. So can you explain how was that possible?
Vreau să comunic mama mea în vârstă de etate.
Okay, first of all, I would like to say that my mother is very old and she lives with me. And at her age, she doesn't have expenses. They are very small. She doesn't have major obligations. And the help, taking into account that we live under the same roof, is absolutely according to the income that she received. My mother always lived with me that period of time. She was just, checking her flat if the tires are okay, if nothing is broken. But again, I don't have the moral right to leave her alone because she's in bad shape. Thank you. In the same year, you said that your son received a donation of 50,000 lei from someone called Sergiu, and this donation was supported only by a written declaration. But he did not have any legal income at that time. Also, you said that Mr. Sergiu received money from his mother, but also his mother at that time didn't have any legal income. Same question. How was that possible? So this donation, without fiscal proof, from where it came? Okay, so Madam Ludmila, the mother of Sergiu, worked for all her life as a dentist, stomatologist. She lived in Chișinău, but then she married someone from Tiraspol. His name is Concer Iurie. So she married this guy and moved to Tiraspol. If you verify that period of time, and actually the Commission received the extracted information from the fiscal entity for Mr. Iurie, her husband, her second husband, you can see there that Sergiu, who is the father of the child, received transfers from his parents. I cannot tell you all the details, but I know that the children of Mr. Conchaev from Tiraspol. One of them lives in America. He's a business person. And the second child is also abroad having a business. But I didn't go into details because if to answer to the question from where the money, in 2021 there are transfers, and the amount is $8,000, if I'm not mistaken, to him. Okay, in the same year, you benefited of a loan of 5,000 euro from Mr. Dmitry. You used it for the renovation of the kitchen. And I want to ask you, do you have any written proofs or anything that can be verifiable that you actually had that loan? Unfortunately, I cannot prove. I cannot bring proofs because this person is the brother of my mother. He lived in Ukraine. He died already. So unfortunately, I don't have anything related to that. After his death, Okay, but when did you give the money back? I didn't give the money back because I just told you he died. The war started, and the day the war started, he actually dies in 3 days. He dies because of stress. He was old, and he died because of stress, not because of the war. He was passionate to produce wine. He had vineyards, but his heart just didn't resist. Okay, let's now remember about a car, Renault car that was taken away for the sum of 10,000 lei. So it was sold, but you wrote that it was for 4,000 euro. So are there any proofs for those 4,000 euro? And the second question is, how come the documented amount and the declared amount are totally different? I also explained this to the Commission. This car, Renault, was a gift to my son from his grandparents when he reached the age of 18 years old. So it was a gift. I didn't have anything to do with the car. No contracts, no nothing. That's why I do not consider this Renault car that has nothing to do with me, mainly in 2021. It was exactly the year my son reached 18 years old. My son was also audited. And the purpose why the car was sold, and I don't know, I'm not aware. Okay, but who actually sold the car, and who took the actual money, and how? Was this a transfer? Was this cash? It was given cash to my mother. Okay, and my mother gave the money to my son because he had to pay the lease for the car that he actually purchased. Okay, and then to close the budgetary deficit for 2021, please explain the flow of income and the one that
circa
went
190.000 de lei.
out, and the difference being 190,000 lei, approximately. Okay, one more time, I can tell you, in 2021, my son reached the age of being an adult. He was not anymore justifying his expenses to me. I can only show you my accounts, because from my accounts there were no payments. That is why my request to the Commission is the same as the previous request. This amount for Renault Megane donation, as a donation, so related to all the payments, lease payments and other payments, not to be attributed to me. And I want to underline the fact that in 2021, the only connection with the cars that belonged to my son was to support sometimes the insurance, to pay for the insurance. I didn't pay any other payments for procurement or for usage. It was absolutely on his shoulders, on my son's shoulders. All the agreements, all the insurances are targeting him as a user and as the owner of the car. That is why I don't think it's the right thing to consider this my expenses. This is not related to my income or expenditures. Okay, thank you. Let's take the year 2020. No, the colleague has a question. Madam Cojocaru, I would like to come back to the subject related to the gifts that were offered by the relatives at the family events. So, I have two questions here. First would be, you mentioned that you have close relationships with those relatives that offer this kind of presents to you. So, my question to you is, did you offer the same type of amounts to the birthday of your relatives? My possibilities, taking into account that I have a daughter of 4 years and a boy of 15 years, were not actually allowing me to make expensive gifts. But when I had the possibility, mainly for the people that were giving me also money for my birthday, I would kind of return the favor. Okay, then the second question. Can you quantify somehow those gifts? Because we quantified the sum that entered, but we are interested also to hear about what went out, let's say. You know, it's so difficult for me now to remember how much was that in 2015. I cannot remember those kind of details. Okay, but in the same time, those amounts that you received from your relatives, you remember very well. It's not about remembering. I just know that my mom came with such an amount because we were also in good relationships with my mother-in-law. She was very generous also, but now the situation changed. It's not anymore the same. Okay, thank you. Okay, our colleague. Madam Cojocaru, I would like to come back to the sales of the car. What was the procedure? What was the procedure of selling? How exactly this happened? I didn't participate in any way in sales of that car. It was the activity of the grandmother with the grandson. So my mother with my son. I think they respected the procedure, but I don't know how they did it. I didn't participate. I was not part of that process. But your son at that time, was he using that car? Actually, he had a driving license because he just turned 18 and he made a driving license. Okay, thank you. I believe we can continue with the year 2022. It was a year when your son bought a new car, BMW X5, 132,000 kilometers, and it was a price of 290,000 lei. But in accordance with the information from the Customs Service, such cars at that time were evaluated on average on 483,000 lei. So the question that follows is how this happened, the fact that this car costed such a small price compared to the average on the market. So, as I mentioned previously, within the evaluation, with the initial evaluation, the BMW from 2014 was procured from a legal entity, and it was a contract of sales, and it was also a fiscal bill, so it was an official document released. Okay, but in the same time, also your son tried to sell this car with a totally different price, 660, much more than the average. I will say what I said before. You know this online platform of sales, 999.md. That's not a platform that shows the whole reality. Moreover, he didn't actually go to buyers. He just he placed that information because he wanted to make some money on this car, because he could at that time. But unfortunately, he was not able to sell it, and there are no proofs that this car was sold at that price. In 2022, you have declared another donation amounting 35,000 lei from your mother. But according to the evidence, the pension that she got that year would not even cover this amount. So how can you justify this donation? The same as I explained previously. So, as I explained, in 2022, the pension of my mother was more than 52,000. And I'm going to repeat once again, we live together. I'm covering her needs. We are eating all together. I'm buying things. She is very old. She never goes on any vacation. She just stays in bed. Okay, thank you.
Okay, let's start by presuming that the finances of a family that lives together must be evaluated together. So, how can you prove, or let me ask, why we should believe that you never got involved in the purchase of the cars of your son as long as you were living together with your son also? I think I answered to this question, also have this in the report. I understand the Council's question, and I understand that the presumption is that living with me, we have a joint budget. But I'll repeat myself, it's not the case. My son was adult, was already employed. In 2022, he started to work in France illegally. He worked for half a year, and the fact that the car was in the backyard of the house where I live doesn't mean that this was a car that I was in any way using or involved in it, in the expenses related to the car. From my side, it was only the food, cleaning, like I was acting like a mother.
I was cohabitating with my husband, or cohabitant. He had his own car, came from Greece after 20 years of work there. I did not have a need to use my son's car. My contribution was only providing food. That's all. The fact that my son has always been working, he never stayed without work or not being interested. I explained that to the Commission, and unfortunately it was indirect evidence, but I tried to provide the Commission with proof that at the time when he was studying at the Computer Science College, by the way, with respect to that college, I would like to inform you. He was a student at the recommendation of a handball club, where the handball club in their recommendation expressed clearly and in plenty of details in the period 2014 to 2016. He took part in the Championship of Moldova. They ranked the first in 2014. Then in Ukraine, the Czech Republic, Romania, Bulgaria. In Austria in 2014, they ranked first, I think. Well, sports, and that was my purpose. Doing sports is like going to the army. It gives you the ability, the capacity to work, and he was always working. He was never afraid, and him leaving to France proves once more, certainly, that he was not afraid to work. Tell me, please, you are stating that your son had various occasional jobs, but maybe you or him have some contracts or payments or proof of payment of salaries for the work that he did. I will explain in the following. In 2017, the summer of 2017, being still a student at the Computer Science College, I can only tell about by indirect evidence. He was hired at Valea Morelor at a cafe. He worked for a summer, but they were not paid because they did not have contracts. And then he decided that he'd rather go and work for a wedding party or a christening party, being security, or maybe a waiter, and he got money immediately paid in cash afterwards. So that was his option. He attended that
IT college or computer science college. He also dealt in some telephones on the market. How can you prove that he was selling telephones on the market? I tried to find indirect evidence about where he was buying some spare parts or something, but there was no official contract. And actually, I was not asking him a lot about that, honestly. Thank you. I don't have any more questions. Dear colleagues, do you have any questions?
Yes, one or two. First, how old is your mother now?
She was born in 1950.
1950. So she is 65 years old.
Ea are 65.
75 years old. 75 years old, sorry, yes.
Da,
Yeah.
75 de ani.
And another question is, do you have a car of your own?
Nu.
No, my cohabitant's car, but I don't drive.
Chiar dacă am permis, eu nu.
I have a driver's license, but I don't drive personally. I can take the trolley bus. I'm fully okay with that.
Impediment în sensul.
I don't see any obstruction here.
Okay, thank you. Mulțumesc.
Are there any other questions by members of the commission? All right, Judge Cojocaru, would you like to make a brief statement before we conclude the hearing? Is there anything you'd like to say in addition to what you've already said?
Da, domnule președinte, stimați membri ai comisiei, vreau să vă
Chairperson, esteemed commission members, I would like to thank you for your attention.
Și vreau să solicit respectuos comisiei să
And I would like to respectfully ask the Commission to find that the delays in Gatskevich's case were not caused by deficient management on my side. The requalification in Caravita case was not an arbitrary act. It was a legal interpretation based on the legal framework in place at that time. There is no evidence proving the existence of inexplicable wealth or benefits not declared by me, and altogether, my behavior, in my opinion, has not undermined the public's trust in proper justice, and it meets the requirements of ethical and financial integrity that are provided for in Law 252. Thank you. That's all.
Well, that brings us to the end of today's hearing. Judge Cojocaru, thank you again for your submissions to the Commission's questions and your response to our questions today. After the hearing, the Commission will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 252. The Commission will strive to complete and approve its evaluation report and announce its conclusion as soon as possible. Today's hearing is now closed. Thank you and good day to everyone.
Vă mulțumesc.
Thank you.